signatures, just as a gut. Minimum, but don't quit with a minimum. Because the way the law reads is on or before that 90th day, you will file your petitions in court, and you are then frozen. You can't add any more after the 90th day. And what will then happen is the court will get all those petitions and start counting. They will cross-check them against the property tax records. And so they want to look and see if, this particular parcel is the same guy, the same couple or whatever, one of the people who owns it in the property tax records, and they'll do a count. And if you hit the 65%, they will then certify the remonstrance and say, okay, you can go to court. If they come up short, they may then hold a hearing, or the city can come in and challenge. For example, one of the ways a city can challenge is if the city has installed sewers. They can require you to sign a remonstrance waiver as a part of installing sewers. It only happens if the city does it, it can't be somebody else. But if you have a whole bunch of people with waivers, they can't sign petitions. Or the city may look at it and say, wait a minute, this particular parcel was signed by Sam Smith, and I looked at the property record card, and it's owned by Joe Jones. Well, it may well be that Joe Jones transferred the property to Sam Smith, and they just haven't adjusted the records yet. So those are things you do in a hearing. But essentially, the first step is getting it certified. The other thing a municipality can do, and this is the reason you don't want to quit at 65, is they can go around to people and say, hey, why don't you withdraw? It's going to take the court a month or two to do all the count and figure this out. We'll do all this. Why don't you withdraw your petition? Well, if enough people do, that you get below that 65%, you're going to lose. So, you don't want to quit at 65. You get every possible signature you can. So that if stuff like that happens, you're covered. Once it is certified, let's say you do a remonstrance and it is certified, then the city is required basically just to go in and show that it has a plan and that the plan rationally says I can provide the services within the time I say I can, and here's how I'm going to do it. And you don't take that on. The courts have long time said it isn't worth bringing in an accountant to take on their plan. You're not going to win that case. So that's what they'll do. They'll present their plan. Then, in order to succeed in a remonstrance, you have a number of things you are required to show, and you have to show each and every one of them. If you show all but one, you lose. The elements you have to show are, one, that you have adequate police and fire protection from some entity other than the city. So in other words, you're showing that the sheriff is providing you adequate police protection and you're getting an adequate fire protection through the township or whatever from somebody other than Ingalls. That's one element. Second element is that you have adequate road and street maintenance or protection provision by someone other than the city, i.e. the county is, either through your own efforts, you're doing snow, but the county's come in and doing road maintenance and doing the things it needs to do, and it's adequate. And that's the second element. The third element is that there is a significant financial impact. And basically that is a tax increase. And it isn't just a little tax increase, it's a fairly significant tax increase. The Whitestown annexation, there has been case law that basically you can literally bring in people say, I'm on a fixed income, it's only 10%, I can't afford that. That's one way to do it, but probably not the best way to do it. In Whitestown, when the remonstrators won there, they showed that as a result of the annexation, the properties were going to have a property tax increase of between 55 and 75%. The court said, I don't really care, in that, but literally the trial court said, I don't care if people can afford it or not, that's significant, that's enough. I will tell you, when I first started doing this, 20% increase, we win every time. That is not necessarily the case today. The courts have been, the appellate courts have been a little more pushy, so, that's one of the issues we would have to look at. once they come up with their plan, is what is it going to do to you? Now, you're not limited to just property taxes. If they have other fees, sewer fees, trash fees, and things like that, that you would have to pay that you are not paying now, that all goes into financial impact. So you look at basically all the charges you may have with them versus what you're doing now. And again, that's another element. The fourth element is that at trial, there are still 65% of the parcel owners or 75% of the assessed value that are opposed. You can get more people to come in, but basically you have to prove that all the people who went out and signed petitions still don't like this. You know, they're still opposed. There are various ways to do that, but that's the fourth element. The fifth element is that it is not in the best interest of the people being annexed, but it's the city's burden to prove that it is. So it's kind of a negative, but it's actually their burden to show that by coming in, here are all the wonderful things we're going to do for you that make you so much better off than you are today. That may be code enforcement because nobody does that, or we have all these ordinances that are, making it a whole lot better to live. These are the services we're going to provide, and so on and so forth. That is their burden. The fact that they have or will have provided sewer or water in the last 3 years can be an element if they've done that. But it's their burden to prove it is in your best interest, and of course you counter that. The statute says that once the remonstrance is certified, the court will try the case in 60 days. I've never seen one of these tried in 60 days. The general is more like 4 to 6 months, because by the time you sit down and build your case, they build theirs. Discovery can go back and forth. That's where lawyers ask each other questions to, tell me what your case is about. You're generally looking at that period of time. Most of these that I've done, the trials have been a day. Court trial only, there are no juries. And then you wait and see. The courts of appeals have, decided cases historically. Basically, the court has said, the Supreme Court has said, that a person has no property interest in who governs him. And therefore, if a city comes in and annexes you, you are not protecting a property right. You simply have a right to appeal as set out in the statute. I've never seen anybody who was remonstrated against that actually felt that they were truly a second-class citizen, but that's kind of what the court has said at this point. We'll see what the General Assembly says when they come out with some legislation. So that's kind of generally the process. I will tell you, the cities, the way they fund theirs is taxes. Don't know what Fortville paid. I know that there was testimony in the government thing. Whitestown spent $203,000 on their annexation up through the date of trial. Not sure Martinville. I know Carmel and Fishers, and those guys, they were spending $1 million plus on all of theirs. All tax dollars, of course. Remonstrators, you're passing a hat. I know, generally when I do these, depends on the issues and stuff like that, I generally tell people to put together a budget of $20,000 to $35,000, someplace in that range. Because, besides getting experts and building the case, that's kind of what I tell people. Whitestown, Kent Franzen, and this was testified to, so I'm not saying anything that's private, agreed to do their remonstrance for $7,500. And he stuck to it. He did tell them after the fact that he'd actually spent $75,000 in legal time doing it, but he made a deal and that's what he did. And they now call him the Matlock of Boone County. But that's the exception. That's not what you're going to find. There are other attorneys who do what I do, generally not at quite at the rates that I charge. The bigger firms are, the guys that are representing the cities are charging generally 2 to 3 times what I charge. I'm not here trying to solicit business on something, because one of the other comments that somebody made, and it's something you need to think about, is the population of Summer Lakes, the voting population, is probably pretty close to the voting population of Ingalls. And should you decide, you know, not worth the fight, but, you know, if we get in, we're the electorate. And all of a sudden, we get to decide, or at least have a very steady say on who's actually sitting on town council. You know, those are things you need to think about. You know, basically what I'm trying to do is kind of educate you on the process, your rights, and that type of thing. But ultimately, at such time as Ingalls starts moving forward with this, because they haven't yet. You know, they've not done a fiscal plan. But when they do, you kind of need to have a feel for, okay, what happens to me? What are my rights? What can I do? You know, that doesn't mean you're going to, I guess you could completely take over the council and then disannex. That's a possibility. You can't disannex without the approval of the city council. But, you know, those are just kind of, I guess, the generalities, the general way the statute works. You know, I don't think any of you have been running down to the council and begging them to annex you. But whether or not you choose to fight, that's another issue. You know, there is actually a process of voluntary annexation where people get petitions. And if you have 51% of the people in the area that have the petitions, they go turn them into the council and say, take us. And if the council doesn't, you can actually sue them and say, there's no reason you shouldn't. You know, and then you have to kind of show, well, you know, we can't afford the services, that kind of thing. And that, here's where that happens. Developer comes along, he's going to develop an area, but he needs city sewer, water, wants police and all that, because it's going to help him sell houses, so he'll voluntarily annex into the city. Or some commercial entity is going to build a factory, but they need city services. So that happens all the time. The vast majority of annexations are voluntary. There are people wanting to be in, but there are involuntary, and that's kind of where you are right now. Anybody have any questions? Yes, ma'am.
Yes. I noticed when C.P. Morgan was building these homes, he encouraged everyone to get the homestead. I was saying that when C.P. Morgan was building these homes, he encouraged every one of us to get the homestead, what do you call it?
The homestead exemption.
That. Yeah. And I also felt, I know a little bit about the law, that we were made to sign or initial an agreement to accept annexation, but it was under duress because we couldn't buy these houses if we didn't agree. And I didn't know if that was legal or not.
No. What basically the way a waiver works, and this, Carmel's really good at this. When Carmel was going to allow a new neighborhood, they would require a waiver before they would give zoning. Completely improper and completely unenforceable. The only basis upon which a waiver is valid if it is in exchange for the city itself providing sewer water. Otherwise, they can make you sign anything. And you know, a lot of developers have people sign them. They know they're not valid too. So it doesn't matter. But no, a waiver just for zoning or something like that is not valid.
The other question I have, I'm sorry, linked to this, is I wanted to get clear on, you were talking about your fees, who pays, and do we have to put it together out of our pockets, or is it done by the county or what?
No, they basically have to be paid by the group that is remonstrating.
Okay, so the individuals that are...
The individuals pass the hat. I mean, that's really what it comes down to. I mean, there are some annexations, and again, I don't know, I've not run the figures. There are some annexations that, quite frankly, what you pay in cost is less than what your new property tax bill would be, and it makes sense. That isn't always the case. And you know, I'm not going to say it is or isn't because I haven't really, have not looked at those facts and figures out here.
Water is the utility that Ingalls made them sign. I was the assessor back then, making all these new houses. Water, that's the only thing Ingalls provides.
Do you remember the fight?
Oh, yeah. They don't have sewer, they don't have electric, like some of those. Water is all they have. And they made them sign a thing that says something like, I will not remonstrate should you choose to annex. I've had that I've talked to an attorney about that in the past years, and he thought they did that in 2002, and here they are in 2014, 11, 12 years later. It wasn't valid because it was too many years ago, is what he was saying, but.
I mean, I'd have to look at it,
You'd have
but
to
I
look
mean,
at
it's an issue I'd want to look at before you'd even think about doing a monstrous.
Yeah, and on that same subject, is it if they provide the services or if they built out the services? Because it's my understanding somebody else paid for the build-out of the water and sewer.
It is, and there is case law on this. They are required to do the build-out. In other words, they got to do the pipes to get them to you, sewer or water, or the waiver's not valid. You know, there have been several cases where, for example, sewers were put in by a regional sewer district, and then the city took over and operated them. That would not be a valid waiver.
Dave Mann actually paid for this $500,000 lift station right over around 800, and he dedicated it to the Falkirk Regional Waste District. He got credits for every house that was hooked up, so that 7 miles of pipe to Ingles, he got reimbursed for all of it.
Any other questions?
Hey, now why doesn't Pendleton, part of Pendleton, what do they have to say about all this? Aren't they losing?
Pendleton doesn't want it.
The question was, what does Pendleton have to say about it? The way annexation works is the first municipality who proposes to annex an area, and that's basically introducing the resolution to start it, has an exclusive lock on that area until they either drop it or go all the way through. So if Pendleton right now, if Ingalls has introduced the beginning of we're looking at doing this, Pendleton's locked out. And they can't do anything until Ingalls either drops it or gets beaten in a remonstrance, and then Pendleton can come in.
Pendleton can't because Ingles is already annexed all the way to the county line.
Well, and you also have to be contiguous. So if you're not touching on Pendleton, they couldn't get you anyway.
We just share a postal code, and that's it.
So do we touch on Ingles though?
Yes.
And
All around us.
Ingles put up that 200-foot strip, that imaginary strip. Pendleton can't jump across it.
There is a rule you cannot annex a strip less than 150 feet. But if they did 200 feet, that's legal.
But where is the strip at?
You'll be surprised, it's the strip that runs from the highway, they came up north on